In today's class, I'll be dealing with the subject Law of Tort. Before going into the details of the subject, let me tell you the topic which I'll be covering in this video. First of all, I'll be telling you the meaning of the term tort. Then we'll be seeing the juridical basis or the rationale behind the law of tort. Then I'll tell you what is the purpose behind the law of tort, because every law has certain purpose which it seeks to achieve. तो देखेंगे purpose क्या है behind law of tort. We'll be also seeing कि क्या there is any scientific definition of law of tort or not, or do we have to refer the statement of Jurist or other law in order to understand the basic element of law of tort. Then we'll be seeing the essential ingredients of law of tort. What exactly comprises tort? Then we will be seeing the two basic maxims on which the law of tort is based. The one is Injuria Sine Damnum and another is Damnum Sine Injuria. तो दोनों मैक्सिम्स का मतलब देखेंगे and we'll see कि which is actionable under law of tort. Then we will be covering that what is the with respect to the mental element, that is whether mental element is relevant under law of tort. जैसे for the Indian Penal Code, that is Bharatiya न्याय Sanhita, we have the basic maxim actus non facitrium nisi mensitria, meaning thereby an act cannot be guilty in itself unless it is accompanied with guilty mind. It means criminal liability के लिए you must have the guilty mind. What is the position in law of tort? That will be seen under the mental element under law of tort. And in this, I'll be explaining you the meaning of the term malice in fact and malice in law. Then we will be seeing along with this that mental element, malice in law and malice in fact के साथ साथ we'll be seeing whether it is law of tort or is it law of torts. So these are the topics which I'll be covering in order to give you a basic idea what exactly is the law of tort. Law can be classified into two. It could be codified law or it could be uncodified law. Codified law का मतलब होता है such subject matter on which we have some law, some legislation, some statute, some act, यानी ऐसे subject matter जिनको पढ़ने के लिए, जिन्हें समझने के लिए we have any कानून. If you want to know whether right to privacy is a fundamental right or not, we have the Constitution of India, which is the supreme law of the land of India, that is the grand norm, an example of codified law. If you want to know कि क्या अपनी प्रॉपर्टी की चोरी हो सकती है, for that we have to refer the new law, the Bharatiya न्याय Sanhita, and in correspondingly the Indian Penal Code, another example of codified law. Personal law, Transfer of Property Act, Indian Evidence Act, that is the Bharatiya Sakshya Adhiniyam, all are the example of the codified law. Uncodified law means such subject matter on which there is no law, there is no legislation, there is no statute, there is no act, and law of tort falls under this category. It means law of tort is uncodified law. आपके दिमाग में एक क्वेश्चन आ रहा होगा, फिर how can we know that is a particular act constitute tort? Tort is based on the decisions of court. It could be Common Law Court of England or the Indian courts. So tort is entirely based on the decision of the court, Common Law Court of England and the Indian courts, and it is an example of uncodified law. So from this chart we get one information with respect to law of tort, that tort is the example of uncodified law. You must have heard the word wrong. Word wrong आपने बहुत बार सुना होगा. Do you know that this word wrong is of three kinds? It could be moral wrong, or it could be social wrong, or it could be legal wrong. समझते हैं what is the meaning of these terms? Moral wrong, social wrong and legal wrong. Moral wrong का मतलब होता है what is wrong in terms of morality. Moral norms पे जो गलत है that we put under the moral wrong. Example, not giving alms to a beggar is an example of moral wrong. What is wrong in terms of society, that is called as the social wrong. If suppose A is a rape victim survivor, in order to save the life of A, the child in the womb of A is being aborted. So killing a child in mother's womb is an example of social wrong. But do you know, we don't have to bother what is moral wrong, nor we have to see what is social wrong. We just have to see what is legal wrong. Legal wrong का मतलब होता है what is wrong in terms of law. What law prohibits and what law make it punishable, that is only our concern. It means we just have to see what is legal wrong. We don't have to consider what is wrong in terms of morality, what is wrong in terms of society. This legal wrong can further be classified into civil wrong or the criminal wrong. Civil wrong का मतलब होता है such wrong in which the legal right of a private individual is violated. Since the legal right of a private individual is being violated under the civil wrong, that's why it is also called as the private wrong. As it is a civil wrong being private wrong, so we can call it as a less serious wrong. On the other hand, criminal wrong means the wrong against society, the wrong against the state, or we can say the offense. That's why it is called as the public wrong, because the right of the public is involved. As the criminal wrong is wrong against the society, you will be finding one of the party as the state in case of criminal wrong. IPC, that is the Bharatiya Nyaya Sanhita, falls under criminal wrong. If we see under civil wrong, following law will fall: breach of contract, that is the contract law is an example of civil wrong, or the breach of trust, or the law of tort. So what information we got from this flowchart? क्योंकि law पढ़ने का यही तरीका होता है. We don't have to cram. We just have to understand the concept. And if you bifurcate the things in flowchart के form में, that will be very easy for you to keep the things in mind. So tort is a kind of civil wrong which is neither the breach of contract nor the breach of trust. It means from this flowchart we can say that tort is the residuary civil wrong. Residuary civil wrong है tort. Again and again I am using the word tort, तो tort की meaning तो समझ ले. The word tort is a French term. In your prelims directly they ask you, is it Latin language का word or French or English, or it depends on the discretion of court. So tort is a French term which is derived from a Latin term tortum, टॉटम एक लैटिन टर्म है जिससे टॉट को डिराइव किया गया है एंड द मीनिंग ऑफ द टर्म टॉटम इज ट्विस्टेड, crooked or unlawful. So we can say tort is such a conduct, tort ऐसा conduct है which is twisted, crooked or unlawful. So we can say tort is the uncodified law, it is residuary civil wrong. Tort is a such conduct which is unlawful, twisted or crooked. Now let us see, do we have any definition as we have contract law के लिए? Contract is defined under section 2H of the Indian Contract Act, an agreement enforceable by law. And a contract is equals to agreement plus enforceability. If you want to know the meaning of the term transfer, that is written in the section 5 of the TPA. If a new interest is being created in a property, then that transaction will be termed as a transfer. But so far as the case of the tort is concerned, we don't have any scientific definition. What is the reason for not having any scientific definition of law of tort? The first reason is, as the tort is uncodified law and the judges decide the case on the basis of fact and circumstance of the case, they do not lay down the principle on which they have given the judgment. So, codified law is one of the reasons for not having any definition of law of tort. Another reason is, tort is still growing. Law changes with the changes in society. With changing scenario, new domains are added in a law of tort. So it is not possible to club up in a single definition. इतना environmental pollution चलता रहेगा तो हो सकता है आने वाले दिनों में Supreme Court might lay down that not wearing mask at public place is a new kind of tort. So tort is still growing, so not possible to give a single scientific definition for it. Moreover, different kind of tort require different specific elements which is not possible to lay down in a single definition. अलग अलग तरह के tort के different elements are there. So it is not possible to write in a single definition which suffice the need of all the kind of tort. So these are the reasons for not having the definition of law of tort. But we can take help of other law or the statement of the jurist in order to understand the basic nature of tort. Let us see from the Limitation Act, section 2M. Section 2M of the Limitation Act of 1963, it says that tort means a civil wrong which is not exclusively a breach of contract or the breach of trust. So from section 2M of the Limitation Act, it says that tort means, whenever you find the word means, it means that definition is complete in itself, that is exhaustive. Tort means civil wrong, it means tort is not the criminal wrong. In the very first flowchart we have seen that. And moreover, such civil wrong जो कि ना ही breach of contract है और ना ही breach of trust है. That is tort is a residuary civil wrong. Now let us say in terms of Winfield, what Winfield has said about the law of tort. He said that tortious liability arises from a breach of duty. Yani tortious liability means the liability under law of tort, it arises from a breach of a duty. Breach means violation. Such duty which is primarily fixed by law, ऐसी duty जो कि law ने fix की है, and this duty is towards the person generally, and its breach is redressable by an action for unliquidated damages. समझते हैं what he want to say in such definition में with respect to लॉ ऑफ टॉट। विनफील्ड सेज कि टॉट के अंदर लायबिलिटी जो है वो अराइज होती है whenever there is a violation of a duty. Duty is such which has been fixed by law. यानी यहां पर पार्टीज ने ड्यूटी नहीं फिक्स करी है। Where the duties are being fixed by the parties in case of contract law, whereas in tort the duty is being fixed by the law. The nature of the duty is general. General duty means everybody is supposed not to defame anybody, be it X, Y, Z. Whereas if we talk about contract, the duty का nature is particular. It is with respect to the parties to the contract only. And on the basis of the maxim ubi jus ibi remedium, ubi jus ibi remedium मतलब where there is a right, there is a remedy. On the basis of this maxim, जब भी breach होगा, such duty which law has fixed, which nature is general duty, the remedy is unliquidated damages. समझ लेते हैं term unliquidated damages को. Damages means monetary relief, that is the compensation. These damages could be liquidated or unliquidated. Liquidated का मतलब if the amount of the compensation is fixed beforehand, then that will be put as a liquidated damages. In case of contract, we get the liquidated damages as a remedy in case of breach of contract, whereas unliquidated damages means such damages which is left to the discretion of the court to decide what quantum of damages will be given. In case of law of tort, we get the unliquidated damages. क्यों मिलेगा? क्योंकि लॉ को पढ़ने के लिए you need to understand WH question with respect to a topic. क्यों है, why, how, when, so that to understand comprehensively a topic. In tort, we get unliquidated damages because the parties are not known unless the tort is committed. Unless your neighbor will play a loud music before the day of your exam, how you will be knowing the tort of nuisance is being committed by your next neighbor? And moreover, it is not possible to evaluate the quantum of damages beforehand unless the tort is committed. अगर आपका एग्जाम है and that is your last attempt, damages हो सकता है आपको ज्यादा मिले. Court might give you more compensation in terms of monetary relief, but to a layman person who has nothing to do with the exam, he is living all well in his life, and if a music is being played as the marriage function was there, तो हो सकता है damages की amount is very nominal. So because of these two reasons, we get the unliquidated damages in law of tort. So according to Winfield, tortious liability तब arise होती है जब breach होती है duty का. Such duty which law has fixed, the nature of the duty is general, and on its breach we get the remedy as unliquidated damages. Let us see what Salmon says. In the wordings of Salmon, he says that tort is a civil wrong for which the remedy is common law action for unliquidated damages. Again he says that tort जो है वो civil wrong है जिसके लिए common law action है for unliquidated damages, and which is not exclusively falling under following, which is not exclusively breach of contract, breach of trust, or other merely equitable obligation. यानी ऐसा सिविल रॉन्ग जो कि ना ही ब्रीच ऑफ कॉन्ट्रैक्ट है, ना ही ब्रीच ऑफ ट्रस्ट है, ना ही ऐसा कोई अदर merely equitable obligation, then that kind of civil wrong will fall under the law of tort in the wordings of Salmon. If we see with respect to the Fraser, then his statement is tort is such a wrong in which there is infringement. Infringement मतलब violation, breach is such wrong in which there is an infringement of right in rem. Right is of two kinds, right in rem and right in personam. Right in personam का मतलब है right which is available against a particular individual. In case of law of contract, right in personam is involved, whereas in case of tort, it is right in rem. Right in rem मतलब right available against the whole world. You have a right to enjoy peaceful premises of yours, and this right is available against the whole world. So, according to Fraser, tort is an infringement of right in rem of a private individual, giving a right of compensation at the suit of injured party. Remedy milegi, and that remedy is compensation, and that compensation के लिए who has to move to the court? The person whose legal right has been violated, meaning thereby plaintiff has to move to the court because it is a private wrong. So Fraser बताते हैं कि ये right in rem का violation है of a private individual, giving a right of compensation at the suit of injured party. If we see Lord Denning का statement, then Lord Denning said the province of law of tort is to allocate responsibility for injurious conduct. It means tort is a unlawful conduct. So Denning के according, tort is such thing which provides responsibility for injurious conduct. So what we can gather from all these definition and the statement? Let us see the concluding statement with respect to the law of tort. We can conclude that tort is a civil wrong. It is tort is other than mere breach of contract or breach of trust, meaning thereby residuary civil wrong. We can say that right or duty which is being violated under the law of tort, it has nothing to do with the agreement which the parties will make. तो right और duty जो violate हो रही है tort में, it has its connection with the law. It has nothing to do with the agreement which the parties will make, and its breach, it is redressable by the action for unliquidated damages. Because the maxim ubi jus ibi remedium says that where there is a right there is a remedy. अगर law आपको rights देगा तो at the same time law will also tell कि what remedy you have in case these rights are violated. Otherwise merely providing rights is of no use. If the constitution says that you have the fundamental right to privacy, but it does not say कि if your fundamental right is breached, you have the right even to approach to the apex judiciary, that is to the Supreme Court. So mere providing right is of no use. It means जब भी right बताई जाती है, on the same hand remedy is given to the aggrieved party. So the remedy in case of law of tort is unliquidated damages. Now let us see what is the juridical basis or the rationale behind the law of tort. The first we have already seen, that is the maxim ubi jus ibi remedium. These are the Latin maxims. Latin is a foreign language, and maxim means just like quotations in English. Ubi jus ibi remedium means where there is a right, there is remedy. It means if the law tell that following are your rights, then at the same time Law will also tell what remedy you have in case these rights are being infringed. Another is justice, equity, good conscience. And when you club these two, that is ubi jus ibi remedium and justice, equity, good conscience, you'll get a concept of social engineering. This is a theory, that is the theory of social engineering, has been propounded by the Roscoe Pound, a propounder of sociological school of jurisprudence, which you will be studying in the law of jurisprudence. The jurisprudence provides that what is the basis of the law, the knowledge behind the law. So, if you club these two, you will get the concept of social engineering. Theory of social engineering says that every law has the purpose to balance the conflicting interest. Conflicting interest जो society का है, that balancing is being done by the law. What kind of conflicting interest is involved in case of law of tort? The plaintiff legal right is being violated on one hand and the defendant the wrongdoer. So between these two conflicting interests, balance is being provided under the law of tort. And the third juridical basis behind the law of tort is sit utro tuo at alium non ledis. This is again a Latin maxim, sit utro tuo at alium non ledis. The meaning of this maxim is you should use your property in such a manner as not to injure another. अगर आपके पास राइट है कि आप अपने प्रेमाइसेस को पीसफुली एंजॉय करो, तो नेबर के पास भी राइट है कि देयर शुड नॉट बी एनी न्यूसेंस कॉज टू हिम बाय योर पीसफुल enjoyment of your premises. So these three are the maxims which are the rational or the juridical basis behind law of tort. Now let us see what is the purpose behind law of tort, because every law has certain purpose which it seeks to achieve through that law. The first is law of tort seeks to create certain norms and conduct for interaction among society so that a peaceful society is established. So one of the purposes is to lay down certain norms and conduct for social interaction among the society. The other purpose is to distribute the loss between the plaintiff and the defendant. Plaintiff means the person whose legal right is being violated. It means you can say the aggrieved party, and defendant means the wrongdoer. So at the trial case, what will be the name of the case in case of law of tort? Plaintiff versus defendant. So to distribute the losses between plaintiff and defendant, law of tort is there. And the last, which is the one of the most important purpose, is to create deterrent effect. In order to deter the wrongdoer and the potential wrongdoers, कि अगर आप tort करोगे, if you will be causing private nuisance, if you will be defaming someone, your liability will be there under this civil wrong. So in order to create deterrent effect on the wrongdoers and the potential wrongdoers, law of tort is being there. So we have seen the purpose behind law of tort. Now let us see the essential ingredients of the law of tort. In order to understand any offense, anything, we will be seeing in terms of ingredients के form में, so as to understand what exactly it constitutes. There must be act or omission on the part of defendant. Defendant means the wrongdoer. तो defendant के part पे कोई act या omission होना चाहिए. Act का मतलब doing something which he was not supposed to do, like publishing a defamatory material. You're not supposed to publish a defamatory material because right to reputation is being injured. Omission मतलब omitting to do something which he was not supposed to do. जो नहीं करना था वो कर रहे हो, जो करना था वो नहीं कर रहे हो. that is being done by the defendant. समझते हैं through one example. This is the fact of a case of Glasgow Corporation versus Taylor. In this, there was a park and fruits of these trees appear as berries, but this tree was the poisonous tree. And what the municipal corporation did, they have not put any notice, neither they have put any fencing. Children, while playing in the park, they thought the fruits to be berries and they ate it. After eating, they died. Now the question arises whether there is any omission on the part of defendant, whether that will constitute tort or not. Answer is yes, because the municipal corporation has omitted to put a notice, fencing, if they are allowing a poisonous tree to stand in the park area. The second ingredient is there must be some legal damage. This is the must element for law of tort. Legal damage matlab, you must not confuse with the term damage and damages. ये एक दूसरे का singular plural नहीं है, both are different. Damages, S, means compensation, monetary relief, whereas damage means harm, loss, injury with respect to the violation of the legal right. Legal damage means there is some violation of legal right vested in plaintiff. So, if there is violation of some legal right, then only liability under law of tort arises. It is not required कि उसे कोई loss हो. Loss हो भी सकता है या नहीं हो सकता है. It is immaterial for an action in law of tort. What exactly you have to see कि क्या plaintiff का कोई legal right है जो violate हो रहा है. It is immaterial whether any loss or substantial loss is there to the plaintiff. अभी समझेंगे through the maxim. So what exactly is required? Act or omission on the part of defendant, and through that act or omission, the legal right vested in plaintiff must be violated. Now let us see the two maxims which are the basis of law of tort. The first one is Injuria, Sine, Damnum. Injuria means infringement of the legal right. Sine means without, and damnum means harm, loss or injury. This harm, loss or injury can be in any form. It could be monetary loss, health pe loss, comfort pe loss, monetary loss or any other thing. Otherwise, comfort, health, peace, any loss is covered under this. So, what is the meaning of the whole maxim? Infringement of legal right without any harm or loss. This is actionable in law of tort. कोई loss नहीं हो, that is immaterial. What exactly we have to see? Whether some legal right, not the moral or the social right, some legal right is being violated. If the answer is in positive, in assertive form, that is yes, then only it is actionable in law of tort. समझते हैं through the case law. Ashby versus White, in which the Holt CJ has given the judgment. The fact of this case is such, the plaintiff was a qualified voter. समझ लेते हैं with your example. Suppose you have attained the age of 18 years. Your name is there in the electoral roll में to cast a vote. You have attained the age of adult franchise. When you went for casting your vote, then the returning officer put a restriction and he said you are not supposed to cast vote, and as he did not allow, so you will not be able to cast the vote. But the candidate whom you want to cast vote, that has won the election despite you are not casting the election. जिसको आप चाहते थे वो इलेक्शन जीत जाता है, लेकिन आपको वोट डालने नहीं दिया जाता है. Though the fact is that कि आपके पार्ट पे there is no irregularity. Now the question is कि क्या आपके पास है कोई remedy under law of tort? Answer is yes, because your legal right to cast vote has been violated, even though no loss has been sustained by you. Same is the fact of this case, जहाँ पे plaintiff was a qualified voter. He was not allowed by the returning officer to cast his vote. The candidate whom he want has won the election, but as his legal right is being violated, so he will get the remedy in law of tort. Same kind of fact is that in case of Bhim Singh versus State of J&K, 1986 Supreme Court. In this case, what happened that the member of Legislative Assembly of J&K, पहले का time है when Article 370 was existing. So, Bhim Singh was wrongfully detained by the police when he was about to attend the session of the Legislative Assembly of Jammu and Kashmir, and he was not produced before the magistrate within 24 hours of the arrest. If a person is arrested, then he has the constitutional right under Article 22 Clause 2 of the Constitution of India, as well as a statutory right under Section 57 of the CRPC and the corresponding section under the Bharatiya Nagarik Suraksha Samhita to be produced before the magistrate within 24 hours of arrest. But Bhim Singh was not produced, and moreover his constitutional right to attend the assembly was also being violated. That's why 50,000 rupees was awarded at that time as the exemplary damages. Exemplary damages means to set an example. If you will be violating an illegal right, the compensation, the monetary relief, the unliquidated damages will be given to the plaintiff if there is a violation of some legal right, that is if it is a case of law of tort. Whereas on the other hand, the other maxim says that, which is Damnum Sine Injuria. Damnum means again the harm, loss or injury. This harm, loss or injury could be in any form. It could be in form of money, it could be in form of health, it could be in form of comfort or any otherwise harm. Sine means without and injuria means infringement of the लीगल राइट. तो पूरी मैक्सिम का मतलब क्या हो गया? डैमनम सिने इंजीरिया का हार्म, लॉस और डैमेज विदाउट वायलेशन ऑफ एनी लीगल राइट. डू यू नो दिस इज नॉट एक्शनेबल. भले ही कितना सब्सटैंशियल हार्म क्यों नहीं हुआ हो प्लेंटिफ को बाय द एक्ट ऑफ डिफेंडेंट, if none of the legal right of the plaintiff is being violated by that act, then that is not actionable. This has been laid down in the case of Gloucester Grammar School case by the Hangford Justice. What happened that defendant has set up a rival school in front of the plaintiff school. उससे हुआ क्या? As the plaintiff has put fees ka amount very nominal, he was giving good quality, so all the students start going to his instead of plaintiff, they are moving to the defendant school. So defendant has put a rival school, and in comparison to the plaintiff's school fees mein, he has put very nominal and the quality he was giving good, and because of which the plaintiff was sustaining too much monetary loss. He was not having money even to pay to the members or the faculty members and the other staff who are in their school. Now the question arises कि क्या plaintiff के पास कोई remedy है under the law of tort? You have to check कि क्या plaintiff की कोई legal right violate हुई है by this act of defendant, and the answer is no. Because if any monetary loss is there without violation of legal right, it means that is falling under the maxim damnum sine injuria, that is not actionable. And this has been explained by the Hangford Justice in such a form कि अगर मेरा पड़ोसी मेरी मील के सामने एक अनदर मील बनाता है, बिकॉज ऑफ विच प्रॉफिट ऑफ माई मील हैज बीन डिमिनिश्ड, आई हैव नो एक्शन इन लॉ ऑफ टॉर्ट. लेकिन if you obstruct water or he cause any other nuisance, then that is actionable. So what you have to check in case of law of tort कि plaintiff की कोई legal right violate हो रही है या नहीं, loss harm हो रहा है या नहीं हो रहा, that is immaterial to determine the liability under law of tort. Now let us see कि what about the mental element in case of law of tort. जैसे if you talk about criminal liability, so there we have the maxim actus non facit reum nisi mensit rea. The meaning of this maxim is an act cannot be criminal in itself unless it is accompanied with guilty mind. If I explain you offense with the help of mathematical formula, the offense is equals to mens rea plus the actus reus. Mens rea means the guilty mind and actus reus means consequence of such human conduct which is prohibited and punishable by law. जहां पे दोनों coincide करेगा, liability will be there. It means guilty mind is must in case of fault based liability under criminal law. In case of no fault liability under criminal law, mens rea won't be seen. That will be the case of strict liability offences. Rape, bigamy, dowry death are the example of strict liability offences. Do we have such thing in law of tort? Answer is no. It all depends on the law of tort कि mental element required है या नहीं है. If it is a case of assault, battery, conspiracy, defamation, false imprisonment, then in that case state of mind of the wrongdoer will be seen. But if it is a case of vicarious liability, defamation, conversion, then in that case it won't be seen. So conspiracy है, assault, battery, false imprisonment, malicious prosecution, वहां पे state of mind of the accused will be seen. Whereas if it is the case of vicarious liability, conversion ka tort or the tort of defamation, mens rea, that is the mental element of the wrongdoer, won't be seen. It means it is dependent on the kind of tort कि mental element relevant है या नहीं है. Now let us see the term malice in fact and malice in law. Malice का मतलब if anything is done with ill will, with spite, with vengeance, बदले की भावना से कोई भी किया गया काम, that is said to be done maliciously. There is two terms, malice in fact and malice in law. समझते हैं what are these two terms? What is required for the liability under law of tort? Malice in fact का मतलब होता है evil motive behind any wrongful act. It is related with mind. So किसी भी wrongful act के पीछे अगर कोई evil motive है, that is called as the malice in fact. This is not a basic element in case of law of tort. Only in few tort that is required. Like conspiracy, malicious prosecution में we see the evil motive behind the defendant act. Malice in law means willful act done without any just cause or excuse. यानी जानबूझ के कोई काम किया गया और उस काम करने के पीछे there is no just cause or excuse. क्योंकि अगर उस काम करने के पीछे if there is any excuse or just cause, then there won't be any liability because that act will be justified then. What I mean to say, in order to create the liability under law of tort, what is must? Malice in law is must. Because if malice in law is there, it means the act is not legally justified. समझ लेते हैं through the example. There are certain situations where the act is already justified. जैसे if the act is falling under general defenses, जनरल डिफेंसेस मतलब there won't be any liability of the wrongdoer. ये नहीं कि ज्यादा की जगह कम liability हो जाएगी. There won't be any liability. Complete exoneration on the part of wrongdoer. तो जनरल डिफेंस का केस है, be it the voluntary not with injuria, defense of consent, accident, plaintiff the wrongdoer, mistake, right of private defense, or the necessity, or the statutory authority. Either of the 8 में case will be falling. There won't be any liability of the defendant. But there are certain acts which is justified with respect to the circumstance. अगर आप पत्थर किसी लोनली प्लेस में फेंकोगे जहां पे there is no human body is there is no human person, there is no animal. If you in a remote place, if you throw a stone, your act will be justified. But if you throw a stone in a park, your act will not be justified. So these situations are called as the malice in law. It means your act is not legally justified. तो जहां पे भी malice in law is there, you will get the thing कि जो act है वो legally justified नहीं है, not legally justified. समझ लेते हैं through a tabular form में कि what exactly constitute the liability and the law of tort with respect to malice in fact and malice in law. Malice in fact का मतलब होता है किसी भी गलत काम के पीछे evil motive का होना. Malice in law का मतलब होता है जानबूझ के कोई भी काम किया गया and that act has been done without any just cause or excuse. Now let us see कि liability कब होगी under law of tort में of the defendant. If suppose both is present, किसी एक पर्टिकुलर सिचुएशन में मैलिस इन फैक्ट भी है, मैलिस इन लॉ भी है, तो क्या लायबिलिटी होगी? आंसर इज यस, क्योंकि मैलिस इन लॉ ही तो लायबिलिटी करता है. फैक्ट हो भी सकता है, नहीं भी हो सकता है. एज आई टोल्ड यू कि इन फ्यू टॉर्ट्स ओनली मैलिस इन फैक्ट इज रिक्वायर्ड. सपोज द सेकंड सिचुएशन इज मैलिस इन फैक्ट इज देयर लेकिन मैलिस इन लॉ नहीं है, तो क्या लायबिलिटी होगी डिफेंडेंट के अंडर लॉ ऑफ टॉर्ट? आंसर इज नो. This comprises the liability under law of tort. It may or may not be there. The third situation is कि malice in fact नहीं है लेकिन malice in law है, तो क्या liability होगी? Answer is yes. Fourth is none of these is present, then obviously there won't be any liability. So what we see, malice in law is must. Malice in fact हो भी सकता है या नहीं हो सकता है depending on the nature of tort. That's why in the very beginning I told you there is no definition of tort because it is not scientifically possible to give a single definition which comprises all kind of tort. Now let us see the concept of कि क्या ये law of tort है और it is law of torts. Tort का मतलब है for every wrongful act जिसके लिए कोई भी जस्टिफिकेशन नहीं है, that will be putting under the law of tort. हर वो wrongful act for which there is no justification, that will be classified as tort. And Holt, Pollock, Pratt, Winfield, all are the supporters of this. आपके एग्जाम में पूछते हैं डायरेक्टली. In mains also, in Bihar Judiciary, they have given one question on malice in fact and malice in law. This time only, this result of mains is awaited. In prelims, they ask you who is the supporter of malice in law, malice in fact, who is the supporter of law of tort, law of torts. What about damnum sine injuria, injuria sine damnum? Because this constitute the basics of the tort. So, tort का मतलब ऐसा wrongful act जिसके लिए कोई भी justification नहीं है, that will be called as law of tort. Law of torts का मतलब होता है there are certain number of specific tort, यानी tort का नंबर कुछ specific है जिनके beyond liability under this law does not arise. According to the concept of law of torts, there are certain specific number of tort beyond which liability under this branch of law does not arise. समझ लेते हैं through the example. Suppose there are 8 tort. So according to this law of torts, अगर डिफेंडेंट का एक्ट इन्हीं 8 में से किसी में फॉल करेगा, जस्ट फॉर एग्जांपल आई एम सेइंग 8 tort. If defendant act is falling in either of the 8, then only he will be liable under the law of tort. Otherwise, there won't be any liability of the defendant. On the basis of this, Salmond has given, that is, Salmond has propounded a theory which we called it as the pigeonhole theory, as the Salmond is the supporter of law of torts. समझ लेते हैं what is this pigeonhole theory. Suppose these are the pigeonholes and each pigeonhole comprises different tort. सारे ये pigeonholes हैं और हर pigeonhole represent कर रहा है different kind of tort. Let the first one is of assault, this is of battery, this is false imprisonment, this is defamation, this is strict liability, this is absolute liability, this is conspiracy, this is conversion, this is nuisance, this is deceit, this is negligence, this is malicious prosecution. It means every pigeonhole corresponds to particular tort. So according to the concept of law of torts, अगर डिफेंडेंट का एक्ट इनमें से किसी में भी फॉल करेगा, then only the liability under the law of tort arises. If his act is not falling under the numbered tort, there won't be any liability. Which of these two concepts you'll approve? Because one is the narrower view, law of torts, and law of tort is the broader view, क्योंकि tort is a still growing law. हो सकता है आने वाले दिनों में as we are facing the problem with respect to the health, especially with respect to the environmental pollution, so there might be too many torts as laid down by the apex judiciary. Maybe with respect to the AC they will put restriction कि after few years seeing the rating and all, CFC बहुत ज़्यादा emit हो रहा है, will not be able to achieve our goal to reduce the emission. So there will be a check on it. It could be a new kind of tort. So this concept is narrower, whereas law of tort is a broader concept which says that any wrongful act for which there is no justification, liability under law of tort arises. So from all this we can conclude that law of tort is a civil wrong, ऐसा civil wrong जो कि ना ही breach of contract में fall करता है, ना ही breach of trust है. It means it is a residuary civil wrong. If suppose a wrong is such which is falling under both, वो tort भी है as well as it is crime. So whether the plaintiff have remedy under both or both the law or only under one. समझते हैं through the example. Suppose A had made a trench, गड्ढा बना दिया है on the highway. If a trench is made, obviously the public must be obstructed. It means it is a case of offence of public nuisance as given under section 268 of the IPC and correspondingly 270 of the भारतीय न्याय संहिता. A ने गड्ढा बनाया है, B was running late to the classes, फोन पे बात करते हुए आगे प्रोसीड कर रहा था and he has not seen that trench and he fell into it. It means with respect to B, private nuisance has been caused, which is one of the tort. Now the question arises कि क्या B के पास remedy है under both law? It means whether he can claim compensation under law of tort for the private nuisance as well as he can claim punishment for the offense of public nuisance? Answer is yes, because the kind of wrong is different. One is civil wrong, another is criminal wrong. So B has remedy under both of the law. But if the act is such that it is falling under two of the civil wrongs, तब क्या plaintiff claim कर सकता है under both law, or he has remedy under one of the law? समझते हैं through the example. Suppose X was going on a journey. He has given his cow for safe custody to Y. What Y did? कोई खाना नहीं देता cow को, and because of which that cow died. What Y has committed? He has committed the breach of contract of bailment. Contract of bailment का मतलब where the goods are being delivered for certain purpose, that when that purpose is achieved, the goods shall be returned to the person delivering it. So such kind of contract is called as contract of bailment. If you go give your clothes for ironing, if you give your clothes for dry cleaning, if you put your car for in parking for safe custody, that all are the example of bailment. So Y has committed the breach of contract of bailment, and moreover he has committed the tort of negligence. His duty of care was there towards the cow, and he has omitted that duty, and because of that duty the damage has been there. It means he has committed two kind of civil wrong. तो क्या X के पास रेमेडी है कि दोनों लॉ में कंपनसेशन क्लेम कर सकता है? One under law of contract, one under law of tort? Answer is no. He can claim only under one law, because the nature of the wrong is falling under one. Civil wrong है, so either he can ask for compensation under law of contract of bailment का for breach of it, or he can ask for damages under the law of tort for the tort of negligence. So if a wrong is falling under two different kind of wrong, remedy is available under all. If it is falling under same kind of wrong, then he has to choose one of the remedy which is being available to the particular situation में, what remedy is there, which is dependent as per the fact of that particular case. So tort के case में we used to get unliquidated damages. We don't have any scientific definition, but from the other statement, that is the statement of the Jurist and the Limitation Act से, we have got the essential element of it. There must be violation of some legal right vested in plaintiff. It is immaterial कोई harm हो रहा है या नहीं हो रहा है. If there is any kind of legal right being violated by the act or omission, it could be act doing something which he was not supposed to do, or omission, कुछ करना था which he has omitted to do that. Because of that act or omission, there is some legal damage, that is the violation of some legal right vested in plaintiff, then only it is recoverable as per the maxim Injuria Sine Damnum. So we have seen कि for law of tort, it is not the quantum of loss which we have to see. However substantial loss is there, that is not recoverable. कितना भी loss क्यों ना हो जाए. What is the litmus test? The litmus test is violation of some legal right which is being vested in plaintiff. If we want to see the difference in law of tort and law of contract, so we can say that law of tort is uncodified law, whereas law of contract is codified one. This is uncodified and contract is codified. If we talk with respect to right, so right in rem is there under law of tort, whereas right in personam is there with respect to law of contract. If we talk about duty, in tort, it is the duty which is being fixed by law and the duty ka nature is general, whereas in contract, the duty is being fixed by the party and the duty ka nature is particular. If we see in terms of remedy, we get unliquidated damages in case of law of tort and liquidated damages with respect to law of contract. And with respect to tort versus crime, what is the difference in these two? Tort is a civil wrong because the right of a private individual is violated. That's why it is called as private wrong. As it is a private wrong, meaning thereby less serious wrong, whereas on the other hand, crime is the wrong against the whole society, the whole state. That's why it is called as the public wrong. In case of tort, the injured party, that is the plaintiff, has to move to the court, whereas in case of crime, state itself will take the action against the wrongdoer, that is the accused, because crime is the wrong against the whole society. In this case, the remedy is given in form of damages, whereas in case of crime, accused is being punished in either of the 5 forms of punishment. It could be death sentence, life imprisonment, imprisonment for a term, or forfeiture of property, or fine. So these are the basic difference between the law of tort and crime. Hope you have understood the law of tort. Thank you.